Good evening. Welcome to our juvenile justice portion of the parenting series. I'm Susan Blanco and I'm a local attorney and I'm also a guardian ad litem. So I actually represent children in delinquency proceedings as well as protecting children's rights when appointed by the court. I am a NAC certified attorney, which means that I actually take a separate exam that proves proficiency in working with children in all different arenas. And so I have a lot of background and experience working with kids and hoping that I might be able to share some information with you this evening about the delinquency system. So I've given you some information and I have a PowerPoint presentation that my presentation will kind of follow alongside with. And the first real slide that is involving the system is really talking about how children enter into the system. So generally speaking, the children will first be in contact with a police officer, and the officer at that time will decide whether or not there's enough information to either write a ticket or take the case to the district attorney's office. So most people are familiar with just receiving a ticket like you would on the side of the road, like if you're getting a traffic ticket, speeding ticket of some sort. That's what usually happens when kids are cited with a petty offense or with a misdemeanor. So if the kids are being investigated for a felony offense, they won't receive a ticket like you are probably used to seeing. The felony cases have to be screened by the district attorney's office, and the district attorney's office decides if there is enough information there that they would prosecute it as a felony. If the ticket is a felony ticket, the district attorney's office will generally mail a copy of the summons with the court date indicating when the child and the parent needs to come back to court. If the ticket is not a felony, if it's just a regular misdemeanor or petty offense, you'll just get a traditional ticket, and then that ticket will indicate when you need to come back to court. A question that's frequently asked of me at the office is, what happens if I refuse to sign the ticket? If I sign the ticket, am I admitting guilt? You're not. A signing of the ticket is generally you accepting the court date so that service has happened. So after a ticket is issued to a child or after a felony is summoned to come to court, then the court case takes one of two different paths. It can either go into a diversion program, which means that the district attorney's office is agreeing not to prosecute the case and allowing the child to go to the center and receive some services through the center, or the district attorney's office will proceed to take the case to court, okay? And at that time, you will be in front of a magistrate and it will begin the formal process of the court proceedings. So a little more information on diversion. District Attorney's Office controls who does and does not get diversion. So it is not something that the magistrate or a judge can give to a child. It is only something that the District Attorney's Office can offer. It does not involve a plea, so children who are offered diversion maintain a lot of the same rights that they would have as if they were going to court for the first time, even if they fail the diversion program. So a child who comes to diversion and is unsuccessful can still have the right to an attorney and can still have a right to have a trial, and they still have that innocence about their case. So diversion is kind of a defense attorney's dream come true if there are bad facts in the case, because we can still preserve so much of our clients' rights if they're in the diversion program. The length of time is also in the discretion of the district attorney's office. Some diversionary programs will only last about 3 months. Some will last 6 to 9 months, depending on what level of care and support that the DA's office and the center think that a family or child needs. One of the benefits, in addition to maintaining all of those rights of diversion programs, is that the children can come back within a year after successful completion and make a request to seal their record. So when children are looking to apply for colleges and jobs, they don't have to worry about the background checks bringing up even the ticket itself. So one thing that is a misnomer is a lot of times families will say, I thought that the ticket would never show up. My child completed something successfully and the DA's office or somebody told me that the case would be completely dismissed. When children are cited with a ticket, the ticket itself will oftentimes appear in their criminal history. In order to get rid of all of that history off of their criminal background checks, you actually do need to come back in and pursue expungement. So that is something that's really important for parents to keep in mind. Another thing is the misnomer that it's on my juvenile record, so it doesn't really matter anyways. That is definitely false. When it's on your juvenile record, it follows you forever. And though it may not be used against you the same way as an adult conviction can be used against you, it's definitely still there. People can still see it after the age of 18. So it's really important as parents, if your kids are involved in diversion, if you are involved in working at the center, it's really important to advise people that once you reach that 1-year anniversary of completion of the program, you seek expungement. And I'll talk a little bit more about that in a little bit. So if you're not chosen to go to diversion and you're not able to negotiate a diversion, then the other direction the case can go is court. So the next slide is kind of highlighting that the first appearance that you have before the court, we call the first appearance because we're just so creative in the law. So when you go to court for the first appearance, there are some things that you can expect are going to happen that day. First and foremost, you will be advised of your rights. The magistrate will be explaining to you basic rights that every child has: right to have an attorney, and if you can't afford an attorney, the court can appoint a public defender to represent you if you meet the requirements. You also have the right to have a trial. Oftentimes children do not have the same trial rights as adults do, so jury trials are very limited in the juvenile delinquency system. But he's going to advise that there is a right to at least have that trial and be presumed innocent, cross-examine the witnesses who are there to testify against you, choose to testify if you wish to, just basic fundamental rights that everybody has. At the same first appearance, the district attorney's office will be present, and at times parents can schedule a meeting to meet with the district attorney's office. I would recommend doing that with caution, as the district attorney's office is not there to defend the children or to present the children's case. And so you want to make sure that you understand that you are not meeting with a defense attorney when you go meet with the government, which is the district attorney. But they will be there and they will be available if appointments want to be set with them. The court is second going to address detention. The court is going to want to know how the children are doing at home, if there's any concerns for the safety of the child or the safety of the community. If there are issues that raise concern, the court may choose to either detain the children at Platte Valley Youth Services Center, which is our version of juvenile jail, or the court could elect to place the child in the care of Senate Bill 94. For those who are not familiar with Senate Bill 94, it is basically a program that offers ankle monitors and supervision of kind of like a community watch to make sure that the kids are going to school, not using substances, following the rules of their family home. It's almost like being in jail in the community. So there might be some restriction of the child's liberty and in placing the child on Senate Bill 94. If the child isn't detained at Platte Valley. Of course, the child's detention is being addressed, so if there's no concerns, the child very well may not end up in either of those two situations at the first appearance. And the third decision, and one that people often don't realize that they have the choice to make, is whether or not they're asking for the case to be moved in front of a judge. People will often ask, what is the difference between a magistrate and a judge? The judge is elected. The judge is appointed by the governor and elected every time that we are in the voting booths. We have a say on who is a judge. The magistrate is actually appointed at the whim of the chief judge. And so the option becomes that of the child. If the child would like to have the case moved in front of a judge, the first appearance is the first opportunity to do that. With regards to whether or not a child needs to have a defense attorney, we are asked that question all the time. Does my child really need to have a lawyer, and will it benefit the child? Well, First and foremost, I would encourage parents that if they are concerned financially with hiring an attorney, that they apply for the public defender's office. That is a free attorney that is there to advise the child and guide the family through the system. And that service, if you qualify, is an excellent way to have somebody help you in this time if you find yourself in the middle of a delinquency case. There are lots of private attorneys that will help with children's cases, often at a reduced rate. We are one of those offices that will do that. Make sure that when you are interviewing and hiring attorneys that you look for somebody that is experienced in working with children. Children's Code is under Title 19. It's different than adult law, and so you really need to have somebody that's proficient in working with kids because it's such a unique area. The role of the defense attorney is to protect your child and to try to maintain your child's rights throughout this procedures to make sure he's treated or she is treated fairly. It is there to make sure that the child's rights were not violated during the course of interviews and so forth. So consulting with an attorney can often be very beneficial for the child and for the family. I am a defense attorney, so of course I think that it's extremely important to have one. But even if you can't afford one, I just can't encourage you enough to start talking to at least the public defender's office, because it is helpful to have somebody that specializes. The rules are very different for children. The next slide is talking about discovery. So whenever a defense attorney is going to court for you, or if you're going to be handling the case on your own, you will want to get a copy of the discovery. And that is really the legal term that we use for getting all the police reports and the evidence in the case. When we request discovery, we're looking for police reports, any sort of DVDs of any interviews, or perhaps any surveillance cameras to see if there's any evidence of that nature, any audio recordings, witness statements, and I don't like the C word, but any confessions if they're out there. We want to know what it is what evidence is stacked up against our clients. So when you want to request the discovery, you can do that through the district attorney's office. You don't have to have an attorney to get discovery, but if you do retain a private attorney or the public defender's office, they will get a copy of the discovery to review for your child. What you won't get is any of the information that the district attorney is writing down, any of the DA's personal notes or impressions of the case. And you will not get a copy generally of the input from the victim. You might get a victim impact statement that tells you if there's any restitution, any money being asked to be paid back by the victim, but you won't be getting any of the actual contact between the DA and the victim because they will try to keep that out of the discovery process. So the next slide discusses meeting with the district attorney's office. The role of the district attorney is to not only do what they believe is best for the juvenile, but they also have the responsibility of making sure that there's community safety. So the role of the DA is a little bit different than the defense attorney because they are not obligated to protect the child. They have an obligation also to protect the community at large. The district attorney's office also has an ethical duty to make sure that they are doing what is right. And by that I mean they have a duty not to prosecute cases that they don't believe have enough weight that they will be likely to prevail on at trial. So if there's not enough evidence there, part of the DA's responsibility is to dismiss the case. Does your child need to have an attorney when meeting with the DA's office? You can meet with the DA by yourself. Again, that is the government attorney, so most of us would not advise that you do that, but you certainly can. What is the benefit of meeting with the district attorney's office? The district attorney's office is the only office that can offer to a child diversion or a deferred adjudication, which is something we'll talk about in a moment. Those two things cannot be provided by a judge. You can't get them from a court trial. So a meeting with the DA's office generally has the benefit of possibly giving you an outcome better than what you could get by going to trial. People call it plea bargaining or getting a plea deal. The next slide talks about possible outcomes, and I have listed on there several different scenarios of plea deals. One of the plea deals, I have deferred adjudication or deferred sentence on there. A deferred adjudication means that essentially the child will be pleading guilty to a charge. The magistrate or the judge will be holding on to that plea for the duration of about 1 year. And if the child completes all the requirements of probation, the plea is withdrawn and the case is dismissed. In some regards, you can think of it as earning a dismissal in the case. If the deferred adjudication is not offered by the district attorney's office, you cannot get one from the magistrate. It is a contract between the child, the family, and the district attorney's office where the DA is agreeing not to put the adjudication on the record if the child does certain requirements. Usually the requirements are going to be the same terms and conditions of probation. The district attorney's office, the second bullet point there, can also reduce the charge. So theoretically, if the child is charged with a felony, the district attorney's office could amend it and make it into a misdemeanor. Again, most of the time, if you're talking about an adjudication, even if it's a deferred or if it's a straight adjudication, it means that the child will be on some sort of probation, usually for a year. And when I use the term adjudication, that is a term that is very specific to juveniles. You can think of that as the equivalent of the word conviction for adults. So a juvenile adjudication means the same thing. It means the guilty plea is on the juvenile record as an adult conviction. So the further down you'll see it says plea deal might be to go to JISP. What does that acronym mean? It means Juvenile Intensive Supervised Probation. It's generally an 18-month period of probation rather than 12 months. And it's more intensive. The probation department has the authority to place the children on an ankle monitor in their discretion without bringing the children back to court. The probation officer will be checking in with the child more often, and so it's a more intensive form of probation. On the same list of outcomes, I've also listed drug court. Drug court is a specialty court in Larimer County. Not all counties have a drug court. Not all counties have a drug court for juveniles. This is my personal testament of, when I'm trying to think of if a child needs to be in drug court or not, I always think to myself, if it wasn't for the fact that the child has an addiction, would the child be involved in the delinquency system at all? And if the answer to that question is yes, this child would never be in the juvenile delinquency system if it wasn't for an addiction issue, then drug court may be a good potential option for that child. Drug court is a specialty court where it requires the children to come in more regularly in front of the magistrate. It's held on Tuesday evenings, and the children have a little more accountability in front of the magistrate because they see the magistrate more regularly. They also are involved in groups. They're often involved in yoga and required extracurricular activities. And as long as they're maintaining their sobriety, they come to court less and less often throughout that 12 to 18 month period of time. But drug court can last up to 18 months. The last plea deal, it doesn't seem like a deal at all, is the Division of Youth Corrections. And one might feel like, why is that even on here? There's no way that that's a deal of any sort. But for children that are involved in the system that repeatedly come back before the court, there may be a point in time where the court is looking at commitment to the Division of Youth Corrections. And if that's the case, then a defense attorney or a family could try to negotiate with the DA's office an amount of time for the child to be at the Division of Youth Corrections. It's definitely a last resort, but any child that has a misdemeanor or a felony adjudication has the potential to go to the Division of Youth Corrections for up to 2 years, plus an additional 6 months of parole, which parole is kind of like being on probation in the community, but again, it's potential of 2.5 years of the child's life. So we are able to sometimes negotiate amounts of time. So again, consulting with an attorney might help you to understand better about the Division of Youth Corrections if the child is at that point, but that's the very end of the road for a kiddo in the delinquency system. So those are the different options of things that could happen. So the next slide says we're moving on to dispositions. And in a disposition, basically the court is expecting that the family or the attorney come to court, and at that time do one of three things. Either they're going to be accepting a plea agreement with the district attorney's office, pleading guilty to something, or the family or the attorney may request more time. Perhaps there's additional witnesses or evidence and things that we need to gather. Maybe some of the evidence isn't in the district attorney's discovery yet. Perhaps we're independently going to look for some information or do legal research, so we can ask for some more time, and it's in the court's discretion whether they will allow that. Or third, we can request a trial. We can say that there's been no agreement in this case, and we'd like to exercise our right to have a trial, and at that time, the court could move the case if the child is able to have a jury trial. Magistrates cannot conduct jury trials, so the court may move the case in front of a district court judge. The court may actually set a trial date in front of the magistrate at that time, or the court may set the next court date to be a motions hearing, where, if there's suppression issues and issues constitutionally with the case, we would have a chance to go through that with the magistrate. Again, those are things that it's really beneficial to have an attorney help with, and I would highly encourage it if the case is going to be going to trial. If the child pleads not guilty and is found not guilty at a trial, then the child is free. There's nothing else to restrict the child or the family's liberties, because the child is released to be in the community and did nothing wrong, is the finding. At that time, you would want to consider expunging the child's record. If the child is found not guilty and potentially gets additional charges in the future, it could affect the child's ability to come back and expunge later. The worst example, I guess it's the best example, but it's one of the sadder sides of what I do. We had a client once who was trying to become a police officer and had received a misdemeanor ticket when he was in college, and it made his juvenile record ineligible to be expunged. And so he could not get a weapon and complete police academy. So it is really important as a parent, it's really important as a professional to be making sure we keep track of that date, because expungement is a very important part of the case and often is neglected. So if the child is found guilty and is not let go, it is found accountable to the system for doing something that we consider to be a crime, then the court is going to proceed with some sort of sentencing. At that time, the court is going to consider placing the child on probation unless the court feels there's no benefit to having the child in the community, that all the different programs in the community have been exhausted, and that the child must be committed to the Division of Youth Corrections. If the child is placed on probation, there are 3 different programs. We discussed them a moment ago. There's probation, there's juvenile intensive supervised probation, and then there's also the drug court program for kids. The rules of probation are very specific for children. If an adult commits a crime, the likelihood is that a lot of times the adults won't have as many rules as the kids do. So, for example, children are going to have a curfew if they're on probation. And that's not something we normally have adults on, but that's something that kids are going to have as a regulation of part of their court. If they were to violate that, the court, the probation office, the district attorney's office could bring the child back before the court, and it makes the court eligible to resentence the child. What does that mean? It means the child might lose the benefit of probation and could escalate the case up to the point of eventually being in the Division of Youth Corrections. The child is also, as a condition of probation, it's a request that the child remain law-abiding. That would be natural for adults and children alike. The child is asked to follow the rules of their family home. The child is expected that when in school, they're going to have, attendance where they're not missing any classes unless it's an excused absence, that their grades are going to be up to their potential, which generally is a C or better, that the child is not having any discipline problems while at school. So the court is going to worry about that. We don't have that in adult court. The court generally with adults doesn't say, if you're not performing well at work, we're going to bring you back in here. Generally, the court doesn't interfere in stuff like that. But with kids, it's part of their probationary sentence. The children are usually expected to give UAs and BAs. Again, parents will often ask me, why does my child have to do that when my child's case had nothing to do with drugs or alcohol? That is part of the probationary sentence when involved in the juvenile delinquency system. The court could also ask the child to be involved in counseling, could ask the family to be involved in counseling, could ask that the child attend classes, after school activities, mentoring, and all of that could be a condition as part of the probationary program, because all of those things could influence whether the child gets back on track and isn't involved in delinquency any further. The court can also impose no contact orders. Parents will often call and ask, how long does this no contact last? My son can no longer see his best friend, and I want to know how long that's going to last. The court can leave those no contact orders in place for as long as the delinquency proceedings are still open. And by that I mean while the child is on probation. Once probation closes, then those restrictions of no contact orders would also go away. The court also, as a condition of probation, can elect to put a child at Platte Valley and detain the child for a period of time. Not for lengthy periods of time, not for 2 years, but as a condition of probation, the court can require some jail time, some detention time for a child. The next slide that I placed on this presentation was really just to introduce you to a couple extra factors that we deal with when we're in juvenile court. Again, these are unique to the juvenile court system, but you might hear people asking for intakes at the Department of Human Services. Nothing gives parents a heart attack faster than hearing that Department of Human Services is doing an intake on your family. Nobody likes that. So why are they asking for that? Well, it could be because they think that there is something going on in the family that needs a little bit more attention. But generally speaking, they are asking if there's any extra support or resources that are available to that family. And so the Department of Human Services can play a role in making sure that the family receives services that they may not otherwise be able to access. So sometimes being involved with the Department of Human Services actually may be a good thing for the family. It's not as negative as what we normally think when we think the department is opening a case on us. It's startling, but in this case, it may be for the child's benefit to help. You are also probably going to hear mental health evaluation terms being exchanged. Children can have mental health evaluations while they're pending their case to see if there's any additional things that will help the child be successful. Understanding that the goal is that children not come back into the system and that all kids get the benefit of as many services and as many of their needs being met while they're with us. The mental health can include individual counseling for a child. It could also include family counseling. As parents of a child involved in the delinquency system, parents are listed as respondents. And what that means is the court has the ability and the authority to order parents to be involved in counseling, order parents to be involved in their own substance abuse evaluations if the court thinks that's necessary. The court can hold parents in contempt. The court can put parents in jail. It doesn't normally happen, but it's happened before, and so the court can do that because the parents are part of the case. So though a family member may not want to go to family counseling, the court could require that happen. Mental health can also involve substance abuse counseling. Our local mental health does offer a lot of support in that, and so it may also be something that is addressed during the course of the case. Also, you should be aware that because school is such a huge factor in probation, that we oftentimes are wanting to make sure that everything is appropriate at school. Does the child have an IEP or a 504 plan? Is that IEP or 504 plan meeting the child's needs? Is there anything that's happening at school that would hinder the child from being successful? We want to make sure that child is not having any truancy issues. A moment ago, I told you that part of probation means that you can't have unexcused absences. So we want to make sure that the children don't have any truancy issues so that they can be successful throughout probation. In addition, we know that truancy issues generally lead to delinquency issues. Kids who are truant generally are more likely than kids who are not to be involved in the delinquency system. So it's important for us as a system, defense attorneys, prosecutors, magistrates, everyone, to make sure that the kids' needs are being met at school as well. Also, peer groups at school are sometimes an issue, which is, again, that no contact order. Sometimes parents will say, can you please put a no contact order in place? I don't want my son near so and so because that person always gets my kid in trouble. And so sometimes the peer groups are something that can be addressed through the courts as well. The next slide and the last slide is discussing expunging. And I know I've mentioned it several times, but I think it is the last piece of the justice system that is often the most neglected. Families oftentimes feel like, well, I made it through diversion, so everything's all done. And they may be surprised to find out sometimes that things are still showing up on their children's record. So it's very important that after diversion is successfully completed, families pursue, when necessary, coming back in a year to seal and expunge that record. Whether it's necessary or not depends on how far along in the system the ticket reached before the case was diverted. So if the diversion was reported, if the ticket was given to the court and it started to process and later through the court system the case was referred to diversion, something will show up on your child's record. So you need to come back and really mark that as an anniversary date, as important as your child's birthday. 1 year from the end of diversion, come back and double check, do I need to expunge and seal this? If the child doesn't have the benefit of diversion, if the child is involved in a deferred adjudication, if the child is adjudicated delinquent, you're going to want to come back 4 years after probation ends successfully to make that request. Again, if you pick up additional tickets after the 4 years end, you may make yourself ineligible to be able to do that at a later date. So it's just a very important date to put on that calendar. Do you need to have an attorney in order to expunge or seal a record? No, you really don't. We handle those. People contact our office, but a lot of families can do that on their own. An attorney might be able to help you figure out whether you're eligible to apply for it, but that paperwork is available at the courthouse, and oftentimes people take care of that themselves. Certainly there are attorneys, though, that can help with that. The last slide is just my contact information so that if there are any additional questions, you are welcome to give our office a call. It also has a link to our website and email address so that if there's anything further that we can do, you are welcome to contact us, as we'd be happy to help out. So thank you so much for listening and attending. Appreciate it.
Job.